A former state trooper does not want to sit for a deposition, so his lawyers filed to stop it on sealed medical grounds. The judge reads it and orders him to sit anyway. And then something happens that turns a scheduling fight into an investigation. The sealed material, the private impounded materials may have gotten out. So now the judge is not asking one lawyer what happened. He's ordering every lawyer in the entire Karen Reed wrongful death case into court under oath to answer for it. Certifications are due today. Hearing tomorrow. Welcome to Defense Diaries. Hello and welcome to Defense Diaries. I'm Bob Mata, your host. And as always, I am joined by my beautiful and brilliant co-host who sent me the cold open in the smallest possible text humanly available to my aging eyes. I almost made it, but I didn't. Allie, what's up, girl?
Hey, babe. Hey, all. By the way, babe, what's your mic set at?
Probably blaring.
I don't know if it's just me or if it's you.
Let me see. Yeah, dude, it's at like 178. It's so weird. I don't know if like when I unplug my computer that it somehow unchecks automatically adjust mic volume or something, but every time it's cranked up. So hopefully I didn't blow all your ears out. Sounds like Spooks is saying that's exactly what I did. My apologies. So we took one on the chin in softball today. So I'm in a little bit of mourning as our hopes of making it to state in the Little League World Series were dashed tonight. But there's nothing that could cheer me up more than talking shit about Proctor. Let's get into it. So what do we got, babe? You are running this whole thing. I'm coming in blind. You are my Sherpa. Guide me, my love. Guide me.
Okay, so let me just start by saying, all right, so we said sealed medical records. How do we know? Did we say mental health records? Because it's probably what we should have said. But we don't know for sure, right? We don't. But there are what's called context clues. So we're going to start with what started this and go all the way through till today. Only the stuff that deals with Michael Proctor's deposition and the chain of events that started with that.
So we're not getting into Sean Good tonight, right?
We're not. No.
Is that tomorrow?
That is tomorrow. We were going to do a video today.
Oh, yeah.
And then that didn't happen.
They got away from us.
Post it after this live.
I made that killer short that does not have enough views. I mean, a channel, and I realize that probably there's a fair amount. Like, kind of the rule of thumb with your subs is after like 2 years, 50% of them are dormant. That's still a lot of subs to only have, I think, like 1,000 views on this amazing short that I did of Sean Ellis, which if you haven't watched it, fix your life. It's like literally, I think, the best live we've ever done. And in my estimation, that's a pretty high bar.
And it's all Massachusetts corruption. So it's right
Rosemary.
Right in the wheelhouse.
Rosemary, like fought like a savage animal for a decade plus to get Sean Ellis free because he was wrongfully convicted. Just watch stuff, would you? Thank you.
All right. So we're starting with this was filed on June 5th, 2026, emergency motion for protective order. This is Michael Proctor trying to get out of his deposition, which is, what time did he file this? 2 p.m. So it's scheduled for the 8th as it is. So we'll start by reading this.
All right, cool.
Non-party Michael Proctor, Mr. Proctor.
You're not pulling it up?
You want to call himself? Oh, you don't see it?
Oh, no.
What?
Oh, no. Oh, no.
Oh.
Oh, yeah. Oh, yeah, there it is.
Oh, boy. I
Oh,
don't know how I
boy.
did that.
We're
All
already
right.
on
So
fire.
he doesn't call himself disgraced former Trooper Proctor. Just stick with good old Mr. Proctor.
And
Hereby
he's
moves.
got some nerve not even referring to himself as Proctored. That's his new name. Like, if you guys didn't see the Mr. Hanky, the Christmas poo with Proctor's head on it, which has turned him into Proctored, you're missing out. That was Allie just knocking
Well,
it out of the park. I'm like, look, I want Mr. Hanky's head removed and Proctor's head replacing it. He then becomes Proctored. So I could tell already, if you're gonna leave us a comment that we seem disorganized, keep it, save it. I don't want to hear it.
this is
I don't
very
care.
structured and organized. So I don't care what people are going to say.
I don't care
I've
either.
got,
I
I've
don't
got,
care.
I've got everything mapped out.
Uh-huh.
As I grab my piece of paper. So anyway, Mr. Proctor hereby moves this honorable court, pursuant to Massachusetts Rule of Civil Procedure 26C, for a protective order as to his deposition presently scheduled for June 8th, 2026. This motion is supported by ample good cause,
Ample.
as set forth below. All right, you start, babe.
All right. So Mr. Proctor is not a party to this matter. He is, at best, a mere fact witness. Although Miss Reed has litigated this case extensively in the media, to the best of the undersigned's knowledge, only 3 depositions have been taken in this case. Miss Reed's desired litigation strategy aside, Mr. Proctor will be produced for his deposition, but the previously agreed upon date of June 8th, 2026 is no longer workable due to a variety of circumstances as described further herein.
A variety of
Oh,
circumstances.
given
Okay,
Miss Reed's unwillingness to accommodate a requested scheduling change and representations that she intends to go forward with the deposition, Mr. Proctor hereby moves for a protective order on an emergency basis. Footy 1, pursuant to Superior Court Rule 9A D1, the provisions of Superior Court Rule 9A do not apply to emergency motions. As noted further below, and as it pertains to Mr. Proctor's personal circumstances.
personal circumstances.
Oh, yeah. Oh, yeah. The undersigned was only recently made aware of the circumstances necessitating a continuance of the deposition. Just learned it.
And if
I
you
didn't
guys
know.
and if you guys know in the chat, as I'm sure you do, and we all do, how long, so this was June 5th, after Karen Reed filed her motion, her new complaint against Canton and MSP that just laid out all this guy's dirty laundry.
Mhm.
How much time passed? What could have happened to prompt this?
Wait. Up.
Oh, sorry, I forgot.
Remember we had a little
Yep,
footy there.
yeah.
I think was the footy at the end there? Okay. So background. The court is no doubt familiar with this matter, so Mr. Proctor will be brief. On or about January 23rd of 2026, counsel for Mr. Proctor accepted service of a deposition subpoena scheduling Mr. Proctor's dep for April 21st of 2026 at 10 a.m. On March 25th, 2026, counsel for Ms. Reed indicated the need to reschedule Mr. Proctor's deposition due to a scheduling conflict and a judge refusing to accommodate the date. Thereafter, counsel for Ms. Reed and Mr. Proctor worked out to reschedule Mr. Proctor's dep. On April 3rd, counsel for Mr. Proctor accepted service of a deposition subpoena scheduling Mr. Proctor's deposition for June 8, 2026. The undersigned advised counsel for Ms. Reed of the scheduling conflict on June 5th. Counsel for Ms. Reed indicated that Ms. Reed would not agree to reschedule Mr. Proctor's deposition. Argument. You want to get into it?
Sure. Put up any comments that answered the questions here. The scheduling of trial and conduct and scope of discovery and protective orders are issues within the sound discretion of the motion or trial judge, citing relevant cases, and pursuant to Mass Rule of Civil Procedure 26C, upon motion by a party or by the person for whom discovery is sought and for good cause shown, the court in which the action is pending, or alternatively, on matters relating to the deposition, the court in the county or judicial district, as the case may be, where the deposition is to be taken, may make any order which justice requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Citing case law. Good cause exists, allowing the instant motion due to 1, existing practical and trial obligations of Mr. Proctor's counsel. They've known about this for how long? And now, okay. 2, Mr. Proctor's personal circumstances. Could we be any more vague, babe?
Vagooey.
All right.
I like to say.
And the lack of any cognizable prejudice to Miss Reed in rescheduling this deposition, which is sort of ridiculous. First, counsel for Mr. Proctor was scheduled to try 3 separate cases during the month of June, 2 of which did not, unfortunately, go forward, 1 of which did go forward, all of which required extensive trial preparations. The undersigned was scheduled to begin a 3-week trial in the United States District Court on May 18th, 2026. Cites the case. That case settled on the eve of trial. All right. Still, Attorney Crotty was scheduled to begin a multi-week jury trial in Superior Court in the matter of, they cite the case, which was continued at the final trial conference.
Typo. There's a T missing in matter. They have mater.
Okay.
Like the tow truck in ours.
It happens. Lastly, Attorney Deganji was engaged on a trial in Superior Court in the matter of Thompson v. Town of Sherborne. The jury returned its verdict yesterday, June 4th, 2026. These existing practice and trial obligations hampered counsel's ability to confer and prepare Mr. Proctor in advance of his June 8th, 2026 deposition, and renders the June 8th, 2026 date an undue burden. Now, can someone tell me what in the hell could possibly make you wait? I mean, I'm going to wait till after all my shit gets continued and my cases are over, and then, then I'm going to tell you that I don't have time to do this. It's highly suspicious.
Highly suspicious.
Due to personal circumstances, Mr. Proctor has also been unavailable for deposition preparation.
Ooh, preposition H?
Yes, the undersigned only became aware of these circumstances recently. Counsel for Mr. Proctor will, if the court so desires, provide additional information to the court regarding Mr. Proctor's personal circumstances and need to reschedule. Footnote 2 says, as noted above, Ms. Reed has litigated this matter extensively in the press. See Town of Canton's opposition to defendant's motion to compel, noting that immediately after the administrative leave letter for a Canton police officer was produced to the defendant, however, copies of the letter were posted online. What the hell? I don't know. Maybe it was the way the quote that they wanted to use just kind of went like that. Third, this motion should be allowed because Ms. Reed cannot demonstrate any prejudice resulting from the requested relief. And they cite a case finding no error where abuse of discretion in issuance of a protective order based on delay in expert viewing confidential information. I mean, why the hell that one's there, I do not know. To be abundantly clear, Mr. Proctor is not seeking relief under Mass Civil Rule Procedure 26C1 that discovery not be had. The relief sought here lies in 26C2, namely that the discovery may be had on specified terms and conditions, including a designation of a time and place or manner. In other words, it is a scheduling dispute, not an outright refusal to produce discovery sought by Ms. Reed. Ms. Reed can show no prejudice based on a short delay in completing one of the 20 depositions Ms. Reed has indicated she intends to take. Moreover, Per the Superior Court docket, the fact discovery deadline in this matter is currently August 17th, 2026, with over 2 months
2 months
left to complete discovery. The parties should be readily able to identify an agreeable date for this non-party deposition. And then in conclusion, for the reasons above, they're asking for the protective order. The disagreement arises from nothing more than a scheduling dispute, which the undersigned bring to this, because I guess there's 2 lawyers that signed it, bring to this honorable court out of necessity due to misreads refusing to accommodate a schedule change. Mr. Proctor respectfully requests that this honorable court allow Mr. Proctor's motion for a protective order. And just because sometimes you guys want to know, it's signed by Matthew Hamel and lists all the, you got Crotty, Hamel, and Diganji.
Hey, let's go get us some pizza. Sorry.
All right. June 5th. So after that, we get a hearing.
Oh, yeah.
And this hearing is in 2 parts. So we are going to start with part 1, cover what happened between part 1 and part 2.
Courtesy of the Trial Channel, which, by the way, happy birthday. It's
to the Trial Channel?
To the lovely female that operates that channel. It is her birthday today. So happy birthday to you.
Happy birthday.
And everybody go sub over there. She does amazing work. She's always incredibly helpful. She's always willing to share her work, which we are eternally grateful for. So thank you very much, because what she does, it's so clean, super clean. These are all super clean, makes our job easier. So thank you very, very much.
We know a lot of you have seen all of this, but you've seen it broken down. Like, one day there was this, then another day there's this hearing, and then another day there. So we're putting all the things relative to this. Nanook seems to like it, our dog, in one spot.
Down.
This is the hearing that stemmed from the filing we just read.
Fancy tech there, buddy. You didn't do shit. Nothing's playing. We can't see it.
What?
I kid you not. Is it there? No. What are you talking about?
It says it shows on my
end.
You
got to add it to stage.
Why is that happening?
I don't know.
That's the second time that happened, which is bizarre. It's never been a thing before.
I don't know. The dog's not happy with you, though.
I don't know what the hell he's doing. Go back.
He clearly sees a rabbit.
Well, close your door. Mute your mic while he's doing it.
Okay.
Jeez. All right, here we go.
Your Honor, may I proceed?
Yes, please.
Your Honor, for the record, Civil Action 2483 CV 0692. This is Paul O'Keefe individually and his personal representative of the estate of John Joseph O'Keefe III et al. For C&C Hospitality, LLC, doing business as C.F. McCarthy's et al. Counsel, please identify yourself for the benefit of the court and the record, starting with plaintiff's counsel.
Good morning, Your Honor. Dan Buck for the plaintiffs.
Good morning. Who do we have for C&C?
Good morning, Your Honor. Lincoln Rose on behalf of C.F. McCarthy's.
Good morning. And for the other establishment?
Good morning, Your Honor. Attorney John Dilly for Waterfall Bar and Grill.
Good morning. For Ms. Reed?
Good morning, Your Honor. Damon Seligson for defendant Karen Reed.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Your Honor. Aaron Rosenberg.
Good morning, Your Honor. Arthur Maravellis for Karen Reed.
Well, welcome to all of you. Which one of you is going to be speaking?
I am, Your Honor, Damon Seligson.
Thank you. And for the deponent, Mr. Proctor.
Good morning, Your Honor. Matthew Hamel on behalf of Michael Proctor.
Shouldn't he be the one talking?
Good morning, Attorney Hamel. Apologize for the delay, but as is usual, our technology in the courts is not well equipped to do things such as this on the fly. So
sounds like a little YouTube channel.
Attorney Reed, excuse me, does Ms. Reed's attorneys want to be heard further on the motion to impound beyond what you wrote in opposition?
Your Honor, on the beyond what we've written in the opposition, no. With respect to the motion to impound only, we believe that certain aspects of it are appropriate for impoundment, but the majority of it is not, and that we stand by that position, Judge.
Okay. Attorney Hamel, do you want to be heard further?
Yes, Your Honor. We believe that the motion we've submitted in the materials that are provisionally impounded that we submitted to the court per the court's order readily support impoundment of those materials under Rule 2. We feel that we've put the majority of what we need to put into our papers, but for the court's information, within hours of our firm sending to the clerk and to counsel the motion and the 2 affidavits, which are provisionally impounded per the court's order, within hours, my client and his family members received harassing phone calls pertaining to information contained in those affidavits. I think it's safe to assume that the clerk's office did not disseminate that information on a Sunday afternoon, Your Honor. I obviously can't connect any dots, and I don't intend to do so here, but that is why we are seeking impoundment. This is obviously a very public case. I don't need to tell anyone that. But I don't believe that our client's medical personal information, a non-party to this case, needs to be all over the internet when we're just seeking a new deposition date.
All right, so he just gave up the ghost right there.
Your Honor, if I may respond to
We all knew.
the inference from Mr. Hamel about how.
Right. I actually forgot that he said that there, but somebody had asked on X, like, do we know it's medical information? I'm like, I thought we knew it was medical
Seems pretty
information.
clear to me. He said his medical information doesn't need to be put out to the world. All the
Right.
peoples wrote his affidavit. Here's the thing. Proctor sucks. No one cares. Fuck him.
All right. Let's keep
Sorry.
going.
Not sorry.
Whatever he filed on Sunday ends up on the internet. There is, I categorically deny and
Attorney
reject it.
Seligson, he didn't point any fingers. He could have meant me. I don't know. So let's move on. All right.
Okay, thank you, Judge.
All right. Thank you. So the next issue is the motion before the court. Before we get to that, I find that there's good cause to impound the material that's contained in the affidavits, and I'm going to impound them provisionally at this time for purposes of this hearing. So, Attorney Hamel, do you want to be heard on your motion relative to the deposition?
Your Honor, just briefly, and I'd like to address a few things that were noted in the response of Ms. Reed. Again, we're seeking very limited relief in nature, Your Honor. We're seeking a new deposition date. 99% of the time, I could pick up the phone and call opposing counsel, and this would be resolved without the need to involve Your Honor in the court. That's not the case here. Ms. Reed's opposition.
Attorney Hamel, hang on. I mean, normally you could, but normally it wouldn't be 4 or 5 days before the scheduled deposition. The information that you're relying upon would have been provided much sooner than that.
Understood, Your Honor. And I know Your Honor had a few specific questions in the order that was put out last week, including when we learned of that the circumstances of Mr. Proctor's unavailability late Thursday. We informed counsel of his unavailability first thing Friday. I fully agree that the timing is unfortunate there, Your Honor. Ms. Reed's opposition seems to suggest that we first reached out to our client on Wednesday, June 3rd, about his deposition. That's false, and that's not in the affidavits. We communicated with our client about the deposition back in April when we agreed to reschedule the deposition at Ms. Reed's counsel's request. Again, we intend to produce Mr. Proctor for his deposition, but given the circumstances set forth in the provisionally impounded affidavits, we need a new date, and we believe we have put good cause on this record to obtain a new date.
You state you'll produce him, but you don't give an indication in your filings when.
Yes, Your Honor. As noted in the impounded materials, my client's situation is ongoing. We are in constant communication with him, and we will provide dates as soon as possible to counsel. I understand we are on Mr. Proctor is not a party to this case, but we understand that the court is on an accelerated discovery schedule with a August, I believe, discovery deadline. We can get dates to counsel by the end of the week, if that would be satisfactory, and would be happy to provide a status report to the court on that once that's done.
Would you like to offer anything else, Attorney Hamel?
No, Your Honor. Beyond what's in our papers, we'll rest in our papers. Thank you.
Attorney Seligson.
Thank you, Your Honor. Obviously, we are opposed to the motion for protective order. This is a duly noticed deposition. The subpoena for the deposition went out in April. There was an agreed upon date of June 8th, which we have prepared for, we have strategically planned for, we've incurred costs. Now, 4 days before the deposition, suddenly there is a need to continue it. There is no, other than conclusory statements, which I understand the judge, you judge, you're going to impound, but other than conclusory statements, there's no evidence provided of what exactly is the reasoning for family commitments that may be impacting the ability to attend today, health issues that are causing the inability to attend today, to seek a continuance on the eve of such an important deposition after we have incurred so much time, effort, and expense, including travel. Attorney Jackson traveled from California here to conduct the deposition.
Oh, man.
And we planned around that, and strategically planned around that. And the schedule that Your Honor is keeping us to, this is highly prejudicial to my client. The reasoning is not sufficient. Mr. Proctor says in his affidavit that his attorneys have contacted him on June 3rd to discuss and prepare for his deposition. And then we learn on June 4th that they're not coming after we seek out simple list of attendees so that we can give it to the security desk. At no point from April until June 4th did we learn that there was any issue. Was there any request for any continuance, any request for any accommodation? And we've prepared and incurred costs and expense getting to this point. And we're here today in strong opposition to the deposition being continued.
Attorney Seligson, you used the phrase strategically prepared for.
Yes, Your Honor.
It raises a question in my mind relative to the new Bristol action that you filed last Thursday, I think.
Yes, sir.
So the judge is specifically referencing Karen's complaint, which I thought was filed on the
5th
on June 4th, which was a Thursday, and this is June 8th. So so this is what the judge is bringing up now.
That was filed last Thursday, I think.
Yes, Your Honor.
And Ms. Reed's attorneys were fully aware that Attorney Hamel's office was involved on behalf of Mr. Proctor, correct?
Yes, Your Honor. For the deposition in this case, yes.
Was notice of that intent to file the Bristol action given to Mr. Proctor's attorneys?
No, Your Honor. Firstly, I want to be respectful of the court's inquiry. I also want to be careful how I discuss our strategic attorney work product, attorney-client planning. When I say strategic, I mean sequencing of depositions. Nothing to do with the Massachusetts State Police complaint we filed. Those dates aren't, there wasn't some kind of effort to impact the deposition with the filing of the complaint, if that's what the court is asking. Strategic, as I stated, was with respect to sequencing of depositions in the wrongful death case, which we have been talking about as a team for months. That's what I mean, Your Honor.
So as you can see, and it'll flesh out even more so, the judge hopped on his wording of strategic planning. And I think that is because the judge already had in his mind some thoughts about this. But when he used strategic planning, it makes sense that that would be strategic as to whose deposition you want to do first and whose you want to do second. There is always strategy in that because you hope to get additional information from one, and you also don't want to tip your hand where, you're doing the deposition of one of the Alberts and you ask a question that they're like, holy shit, if they ask this, we better let Proctor's lawyer know that this question is coming. That kind of thing. So there are strategic reasons for that. But as many of you already know, and as we'll see, may serve as a reminder to some of you, the judge had something in his mind and he heard the word strategic and he hopped all over it.
Strategery.
Yes.
Yeah.
Okay, thank you. Anything else, Attorney Seligson?
Your Honor, what I'd like to do is ask the court to deny the motion. And if the court's inclined to grant the motion, we would ask that we be entitled to submit a petition for our fees and costs in having to redo the prep, redo the logistical planning. But again, we'd ask that the motion be denied and that Mr. Proctor arrive for his deposition today and that we conduct it as noticed.
All right. So he just said arrive today and we conduct it as noticed.
Thank you. Attorney Buck, do you want to be heard?
Your Honor, I just want to make it clear for the record that the plaintiffs intend to seek testimony from Mr. Proctor, but don't take a position as to whether that testimony is taken today or in the future.
And again, just remember the plaintiffs in this case are the O'Keefes.
Right. And, they're buddy with MSP in this matter.
They want to depose Proctor too, but they don't care when.
Right.
Thank you.
Strategery doesn't come into play.
Attorney Rose, do you want to be heard?
No, Your Honor, we take no position with regards to the motion.
Attorney Daly?
No, Your Honor, thank you.
The bars don't care. We don't care.
Okay. Thank you, everyone. We're going to take a short recess and I'll come back out. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Good, all right.
He's back.
Your Honor, we return to the record on the matter of O'Keefe versus C&C Hospitality, LLC, and all counsel was present.
Thank you, Mr. Clerk. Mr. Clerk, I'm handing the clerk an endorsement on the motion before me, and I'm also going to read it into the record. For this case to proceed efficiently and for our system of justice to work, certain basic things have to happen. A subpoena needs to mean something. A lawyer's agreement needs to have some meaning. Lawyers need to communicate with their clients. Clients need to keep their attorneys informed. And when given an opportunity to provide support for a party's request, that party needs to avail themselves of the opportunity. Based on the record before me, there is insufficient information to support a delay in the deposition going forward. However, given the claims made in the filings over the weekend, I will delay making a final decision on the motion until 4 p.m. today to give Mr. Proctor's counsel the opportunity to supplement the record before me. The subpoena requiring Mr. Proctor to appear for deposition today is stayed for 24 hours. Further hearing will be held today at 4:15 p.m. by Zoom. I followed up with Attorney Seligson on his reference to strategically preparing for the deposition today because I read in the media of an appearance on the Today Show Friday morning where Ms. Reed said that her new civil lawsuit was always part of a plan that she has. And beside her were attorneys Alan Jackson and Charles Waters, who cast the case as a bid to expose institutional corruption in Massachusetts law enforcement and to hold someone accountable for the death of her boyfriend, Officer John O'Keefe. Although there is no duty on Ms. Reed's counsel to have informed Mr. Proctor's counsel of the intent to file the most recently filed Bristol County action, I think it is unreasonable to have not to done so with a scheduled deposition pending, and then to have filed such action 4 days before the scheduled deposition. The actions by counsel, Mr. Proctor's counsel seeking to continue the deposition at the last moment, and Ms. Reed's counsel filing its new action 4 days before the scheduled deposition with an obviously planned appearance on national television, brought to mind comment 4 to Rule 3.5 of the Massachusetts Rules of Professional Conduct, wherein it is stated, an advocate can present the cause, protect the record for subsequent review, and preserve professional integrity by patient firmness no less effectively than by theatrics. As St. Mary's University School of Law Assistant Professor David Bernardo noted years ago at a conference on professional responsibility, civility in the legal profession is generally defined as treating others, opposing counsel, the court, clients, and others with courtesy, dignity, and kindness. Thanks for appearing this morning. We'll see everyone at 4:15 this afternoon.
All right. So here's what I want to say. And we're going to pull, I'm going
rule.
I'm going to,
as if.
I'm going to pull up the order so we can look at it while we have this discussion, or maybe we don't need it. But you're talking about the judge is saying, you guys are, this is theatrics. But why in the hell, you tell me, babe, why in the hell did the judge go out, write his order, come back on, and instead of telling the parties, I have a written order, I'm emailing it to you, that he reads that entire order aloud to the class on the Zoom?
I mean, he's doing the exact same thing that he's admonishing the attorneys, in particular Karen Reed's attorneys, for doing, which is pandering to social media. Hate to tell you,
it's a bit of theatrics,
seems like a bit
Your Honor.
of pandering, Judge.
Like, what the hell was all that? What in the hell was all of that?
So here, I have a question that I don't know the answer to, and I don't know if you know the answer, but I'm sure people in the chat do. In the MSP suit, is Proctor a named defendant? I'm sure he is. He's got to be, right?
I can't remember now. You're calling me off by surprise here.
Well, I mean, like, that matters in terms of whether or not professional courtesy would have called for them letting Proctor's attorney, who obviously could not have his appearance entered in a case that has not been filed yet, but they know that he is representing Proctor in this matter as a non-party witness. So in theory, what I'm saying is, if in the judge's mind, so let's get that answer, because if Proctor isn't a party in that case either, then everything that the judge said is bullshit. They don't owe Proctor a damn thing. If Proctor's a party in that case, and you know, this thing's coming down the pike, they know it's prepared, they're getting ready to file it any day, and there's...
Oh yeah, he's in the one in federal court that was removed to federal court. So the case that was filed November 2025, that's been removed to federal court, he's named in his personal capacity along with Buchanan and Tully.
But that's a different case.
Right.
And is this dude repping him in that case?
Now that I don't know.
Okay, but what about the fresh complaint, the one against MSP?
No.
All right, so
I don't think so. I don't think he's named in that one. No.
Why do they owe him anything?
Exactly. So that's the other thing I was gonna. So we're gonna take this kind of step by step. So you'll have to pay attention to the chat. So he starts out, with this little spiel. Okay. I mean, this is just not the way your everyday normal orders are written out of, what is this? The Superior Court, courts of this level, starting out with the for this case to proceed efficiently and for our system of justice to work, certain basic things have to happen. You know, a subpoena has to mean something, a lawyer's agreement has to mean something, blah, blah, blah. Like that, again, it's theatrics. It's not even necessary. Okay, so this is the part that we really want to pay attention to here. So he's explaining why he asked, oh, I can't highlight. Why, no. Right? Why he asked this question of Attorney Segelson. And again, it shows this was already in his mind. He already had in his mind that this was strategic, that they had a planned, a scheduled appearance on a national television show, the Today Show. They filed their civil lawsuit, and they did this all right before this guy's deposition, and that was their strategy, and that's their theatrics. But you have to say, like, isn't it even better to have gotten him in his deposition without him knowing everything that you have found, and just start asking him questions, let him lie and lie again and lie again, and then pull it out and slam it in his face? I don't know that, maybe we're going to shake him up and he's going to put this out right before his deposition. I mean, the flip side of that is they knew his deposition was coming up. So they knew he was going to see this before the deposition. So they intentionally did choose to. Wasn't there a deadline though?
I mean,
actually, I think there was a deadline. I don't remember.
The reality is that all the texts and email shit was already out, right?
I don't even know if he knew everything because his lawyer got it. That was part of what they had to go through.
But when did that drop? I can't remember. Like, I don't even know when we did that. Whenever Rosemary dropped the hammer, whenever we did that live, like that
but
day.
Even when
that's why I wanted you to do the flow chart, so we had all the dates as to when shit went down.
So here's the thing, though. When the messages first came out, where the state was like, "Well, we got some shit," they made them turn it over to his lawyer to look at before it even went to the any of non-party defendant plaintiffs in these cases. So his lawyer had long known about it. He had long known about it. So, I mean, why those theatrics would make him have whatever he had going on, I do not know. But clearly the judges, that's why I said, as soon as he said the word strategic, and again, there is strategy to when you schedule your deposition, who goes first and what you want them to know about anything. He already had this in his mind. And that, that she had Jackson and Walters, who cast the case as a bid to expose institutional corruption in Massachusetts. When Bob and I read the complaint, we did both say, I think a judge is going to take issue with this, because they actually cast the complaint in the same way. They kind of put that language right in it. And I knew that's something, if I was on the opposing side, the defendants, I'd say, let's strike this stuff from here. There's no reason for this shit to be in here. But this part here that Bob was talking about, the judge recognizes there's no duty for Reed's counsel to inform Mr. Proctor's counsel. In a million billion years, I would not think to forewarn an antagonistic side's counsel that there is this complaint coming out. You might need to hold your client's hand, because the world's about to know all that he already knows has been located and found in his phone. Babe?
Yeah, I agree completely. I mean, you're just echoing what I said 5 minutes ago. I look, that's why I was asking if he's a party to the MSP complaint, then it's different. Then I think that is a professional courtesy, where you're not playing dirty pool. And in terms of civility, you'd serve him. Say, all right, look, I know the DEP's coming up. This is coming down the pike. You may want to take a peek at it before, we hammer your client in a few days. But, with him not being a party in that thing, they have no obligation whatsoever to turn anything over to him ahead of time. None.
So
Zero.
I do find it strange that the judge is saying right in here, I
Well,
think
as we get deeper into this thing, what's troubling to me, which we'll touch upon again, is that the judge is apparently taking a position on this thing in terms of, look, this is a high profile case. The judge is certainly not ignorant to that fact. The judge knows damn well that the eyes of the world are on this case, just like they were with the criminal case. So, this thing where he's talking about pandering, as an attorney, I'm not tailoring the language that I use ever. Like what my typical writing style is, and I use adjectives. I use words that may be inflammatory because I'm trying to make a point. I'm not pandering to anybody. I'm trying to pander to the court. I'm trying to get the court to understand that we're defending this case, but Your Honor, what you need to understand is that part of our defense of this case is that those sons of bitches, and I'm talking about MSP and Canton specifically Good, are corrupt sons of bitches. And you need to understand that. That goes to the crux of what we're talking about here. That's not something that's collateral. That goes to the heart of part of the defense of this case that the fix was in. I mean, the judge doesn't get to determine how they're going to defend the case. And by doing things like putting language out there, and it goes to exactly what we just saw him do right there when he read the order into the record. That's pandering to social media, because who ran with all the things that he said that could be viewed as anti-Karen Reed? Anti-Karen Reed. They were immediately on Twitter. Oh, the judge is handing it to Reed's lawyers. Oh, like all that shit. I mean, what does he think he's doing with that? It's the same thing that he's accusing Reed's lawyers of doing. It's identical. There is no difference.
And then, like you just said, to make it worse, he puts out this order where he is speaking to the public. He's using, like poetic language and citing old, what was it? Some old professor.
Some professor from, buttfuck university. Who gives a shit what that guy
Saint Mary and University.
He clearly went back into chambers, Googled, give me some kind of professorial type of guy that said something about civility between lawyers. And that was the quote that he came up with, as if it was like some ancient tome, like, oh, this quote came down from Mount Sinai and it's the holy like, what is he talking about?
As St. Mary's University School of Law assistant professor David Granardo.
Guy's not even a full professor. It's not even tenured, maybe. I don't know.
Right. But I mean,
so what's next on the playlist here?
Okay, so now we go back to the second half. Oh, wait, sorry. So now the lawyers had to file, some additional information. That is what he asked to be done. So, and this is what they did. Oh, this is what they filed during that little break. Okay.
See, in this, I want to address this type of question or this kind of comment. So, look, Allie and I have not been covering the civil stuff. We're gonna pick up the ball now. I've watched some of the content. We've been telling you since trial number 1 that if they ever filed civil suit in these cases, that the discovery process is a whole different beast. And I realize that many of you probably have never been sued or have never sued someone in civil court, or, if you were in a little accident case, a fender bender, a rear ender, some kind of soft tissue thing, your insurance company handled it. They sent you interrogatories. You wrote down your answers. You sent them back to them. They typed them in, prettied them up, lawyered them up, and then they sent them to the other side. And then you went and maybe sat for a deposition. This ain't that. There's so many parties involved here. There are so many logistical issues with the amount of depositions that are taking place. With like, you could just look at the docket in this case and you start to get an understanding when you're talking about civil litigation wherein there's no less than 7 parties involved, which means a whole bunch of lawyers and a whole bunch of moving parts and a whole bunch of lawyers that have other cases on their schedules and other depositions that are scheduled in other cases and other trials set and all those things that come along with being a busy civil defense attorney or civil plaintiff's attorney. Either one, scheduling matters. And the battles that I warned you all were going to be coming. None of this shit is surprising and none of this shit is rare. This is not a Karen Reed specific case in terms of a judge getting pissed off about the parties farting around and getting shit done. In every civil case that is being highly litigated, the judge is the referee. He's putting both sides in the corners and he's saying, cut the bullshit. If he thinks one is hitting below the belt, he calls him on it. It's that simple. This isn't some kind of like one-off because it's the Karen Reed case. You don't want to take my word for it. Go spend a day in civil court. Go spend a day and just listen to a full civil judge's docket for a day. Just go sit in that courtroom and hear all the bickering that goes on about the discovery. I warned you guys. There were going to be fighting about everything. What to turn over. I'm not turning this over. This is work product. This is privileged. We're not available on this date. They're trying to force us to go to these. This shit happens in every case that's being highly litigated in civil court. I promise you it is. So anybody that thinks that they're, getting some kind of mind's eye into what this judge is doing, this judge is trying to keep shit on an expedited discovery track. That's what he's trying to do. And he's trying to cut through all the bullshit. Problem is, I agree with Allie that he is doing the very thing that he's accusing Reed's attorneys of doing, which is weird. Don't do that.
Right.
You want to be a neutral arbiter, which is what your job is, then do that. We don't need your extra shit, Judge. Just call the lawyers out on their bullshit and move on. That's it.
Right. And before I pull up the that pleading, I'll just interrupt with Tiffany. Tiffany, thank you for your extreme generosity. And she says,
Yes.
sorry to interrupt, but just joined this live tonight. Please watch the amazing interview with Sean Ellis and Defense Diaries. I've never seen such an impactful interview since ever. Good job, Bob and Allie and Sean and Rosemary. And that was yesterday's live that Bob was talking about earlier on. Okay, so
yeah, I mean, you should watch it. If you give a shit about due process, if you give a shit about justice, I do not forgive you if you don't watch that.
Okay. And thank you, Tiffany. So this is filed.
Super generous.
Look, June 8th, 2/22. So, whoops. So right after the judge tells them they got to do something more. All right. So they say non-witness Michael Proctor hereby moves to provisionally impound Exhibit A, Affidavit of Matthew J. Hamel, and Exhibit B, medical documentation. Attached here to under Rule 2 of the Uniform Rules on Impoundment Procedure. So he says the introduction, he's going to be brief. His earlier motion to provisionally impound his affidavit and the affidavit of his counsel filed with the court on June 7th and served on counsel the same date. This motion is before the court as it related to Mr. Proctor's separate emergency motion for a protective order. And he hereby submits Exhibit A and Exhibit B in furtherance of that and requests that they be impounded. The argument is just legal argument. And then it says the materials Mr. Proctor seeks to impound contain private information concerning Proctor's medical condition. Impoundment is necessary given the public nature of this matter and for the reasons stated on the record at the earlier hearing on June 8th. So just moments before they filed this. Mr. Proctor is well aware that the, quote, allegations of potential embarrassment or the fear of unjustified adverse publicity are not sufficient to support a motion to impound. However, Mr. Proctor is a witness in this case, not a party. And while Miss Reed no doubt has the right to mount her defense, Mr. Proctor has a can't even speak. Countervailing and statutorily recognized right to privacy under Section 214(1)B and a legitimate expectation that his personal circumstances, which bear no relevance to this action, would not be publicly disclosed. And then they cite a case where that stands for the proposition concluding the judge correctly balanced privacy interests and the principle of publicity, where the nature of the information was intensely personal. So we got some intensely personal information here, and noting that a legitimate expectation of privacy ordinarily is sufficient to constitute good cause.
See, here's the thing. If Proctor wasn't a big, giant, flaming piece of shit, I might have some sympathy. But he ain't that guy. And whatever he's got going on, if it's PTSD, if he's having anxiety attacks, you know what? Fuck off. You brought it on yourself. You suck. You don't get to be a piece of shit and then have people have sympathy for you. That's not how this thing works. You suck, dude. You suck as a human being. You're a piece of shit. The things that you write about people that don't look like you are unforgivable. And no one's going to forgive you. Ever. It's out there. Your life has been ruined because of who you are. You have no one to blame, sir, but yourself. And there's no fixing it. So you might as well lean into that shit. And whatever that means, I don't know, bro. But I'll tell you that right now. You might as well lean into it because it's unforgivable. You can't walk it back. You can't stick that toothpaste back in any tube, bro. You can't change the fact that you suck and that you're an awful human being. Those are facts. And if that makes you feel bad, too bad. No one feels any sympathy for you. Man, like this deposition out of any of them would have been the one that I wanted to sit in on. And I have no idea what his medical condition is, but I can guess if I sucked like that and my massive amount of suckery became public and the whole world knew just exactly how much I sucked, I'd feel like a big, giant fucking pile of shit. I wouldn't want to leave my house. I'd be embarrassed. I'd be embarrassed for my children having to go to school who now know what a piece of shit their father is, and they have to hear it at school. I'd feel awful for my wife who'd have to go out into courthouses and hear about what a piece of shit I was. Dude, it's like, I've got zero sympathy for that guy. You reap what you sow in this life. And you know what? He's getting everything he deserves. Sit your ass in the chair and answer the questions. You're supposed to feel uncomfortable. When you're a piece of shit, you have to answer for it. You know, you should have gone to your pals and said, hey, man, you know, I'm real nervous about you filing suit in this thing because you know what? You know as well as I do, they're coming after me. They're going to get all my shit. And it's going to expose me. And you know what? They didn't give a shit. They filed suit. I told you all this dirty laundry's coming out. All of it. On all of them. On everybody. Both sides. All the shit's coming out. Civil stuff is not criminal. You don't have the Constitution to hide behind. In the civil stuff. It's fair game. Like civil discovery is fishing expeditions. It's vastly different than criminal. So, I mean,
and you know, I guess, you know, Proctor's just not the sharpest tool in the shed. And he thought throwing away his phone gets rid of all the stuff in the cloud. So, you know, it's a cloud. It's up there. How are they going to get to that? I don't know.
I can't believe it.
All right. So after they file that, we're back.
I love that. That's awesome.
My great uncle played for them long ago.
Pale hose, baby. You know, this is the White Sox, not the red. just in case you're confused.
Or from Massachusetts.
Yeah.
Okay, so then we pick up right where we left off with this hearing.
Thank you, Your Honor.
For the record, this matter is continued to 4:50.
Good times. What happened?
Yep.
Your Honor, may I proceed? Your Honor, for the record, civil action 2483 CV 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III et al. Versus C&C Hospitality LLC, doing business as C.F. McCarthy's et al. Counsel, if you please identify yourself for the benefit of the court, the record, starting with plaintiff's counsel.
Good afternoon, Your Honor.
We're going to skip this. We know.
Sarah Shipley for the defendant, Karen Reed.
Oh, we might have a new lawyer here.
Good afternoon.
Good afternoon, Your Honor. Damon Seligson for Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg for Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Attorney John Dilly for the defendant, Waterfall Bar and Grill.
Good afternoon.
Good afternoon, Your Honor. Evan Wolk for Miss Reed and appearing on behalf of Alan Jackson.
Good afternoon.
And good afternoon, Your Honor. Matthew Hamel appearing for Michael Proctor.
Good afternoon. Attorney Hamel, do you want to be heard further?
Your Honor, beyond what we put on the record earlier today.
I mean, he's like a weird, distorted, like upside down world Lincoln.
Honest Abe? Wow.
I mean,
you're not wrong. You're not wrong. Put a stovepipe hat on that dude. You got Lincoln right there.
All right, here we go.
Satisfied with what's on the record and the additional materials we've submitted to the court, provisionally impounded. Thank you.
Okay. Before I hear from Ms. Reed's attorney on the issue, does Ms. Reed's attorney want to be heard on the motion to impound the submission?
Your Honor, I can tell from the substance of what's been filed that is going to be impounded, so I don't have an opposition to the motion for.
So I can tell from the substance of what's been filed, considering that it's what? Highly sensitive. What was it that they said?
Whatever. It's like HIPAA shit. Like it's
Right.
just medical shit. You know, I mean, they're always going to impound that. They're always going to give people that privacy right. So, I mean,
Right. So no reason to fight it. All right.
To impound what has been filed this afternoon. But I would like to be heard from on Ms. Reed's behalf on what we discussed this morning.
We'll get there. So I'm going to have a hearing on the issue of impoundment. I find good cause for the same reasons I did this morning. And I'm going to order the attachments to be impounded. So, Attorney Seligson, I'll hear from you on the request in light of the supplemental submission.
Your Honor, the arguments for Mr. Proctor's deposition being continue to change. At first, he was argued to be just a mere witness who couldn't attend because he was unavailable. Then they argued that he was also unavailable for his deposition because his counsel had trials. Now they're arguing that he cannot appear for the reasons submitted in the affidavits. And now we're wondering,
which one is
what was submitted this afternoon? Can he even appear? Or are we going to put this over for a couple of weeks so we can get a new date? So I'm a little concerned and troubled by, so the relief keeps changing. They said in their submissions on Friday and then on Sunday that he knows he has to appear and that he will appear. And now this afternoon, we see something that's more long-term. So I'd like to find out about that from the court and counsel for Mr. Proctor. I'd also like to address, Your Honor, some of the statements that were made this morning by the court and that ended up in your written decision. Your Honor,
Attorney Seligson, you don't need to address that. You heard what I said. You might not agree with it, but we're not here for that right now. We're here Okay, no, we're here for the issue. So do you want to add anything else on the substance of the request before the court?
Nothing on the substance before the court, but I would like
Okay.
an opportunity. I'm compelled to put something on the record to preserve my client's rights, Judge, and I'd like to do that if given the chance, and I would be brief.
Your client's rights were in no way impaired by what I stated. So we're going to move on. If you're all done with the substance of the request. Okay, so Attorney Hamel, do you want to add anything further?
Your Honor, I'll just add that the relief has not changed in our view. From the start, we have sought to get a new date. Again, we're not seeking to preclude Ms. Reed from taking this deposition at all. We are simply seeking a new date for the reasons that we provided to the court already and the reasons we've already put on the record.
Okay. Does anyone else want to be heard?
I know one guy who does.
Hearing from no one. I didn't hear that. I'm sorry.
Your Honor, I guess without sort of running afoul of what you've just said to me, there is a question about notice. You've injected a different type of notice requirement that is perplexing to me and my colleagues about notice of things in advance of depositions, and that's what I was trying to seek clarification about.
Attorney Seligson, the great thing about this process is if I issue a decision, we generally don't engage in a discussion or dialogue about it. You can appeal something if you want to. If you want to submit something in writing for clarification, but I'm not going to engage in a dialogue back and forth. That's not why we're here right now.
Understood.
Okay, so thank you.
So the judge just said, shut the f up.
Right. And look,
this is not the way it works.
This is,
I get to talk. You get to listen.
The way that the judge is operating, and again, if you're not used to seeing civil judges, they just handle shit differently than criminal judges because they sit in cases in their courtroom and hear bickering attorneys all day long on all the different cases, because as you're moving towards trial and almost everything settles in civil court, understand that it is not criminal. And everything in criminal pretty much pleads out. So, I mean, that is the way that the court system operates. It operates under the guise that we're going to try to have the parties work shit out because, frankly, we don't have the time or wherewithal to try all these cases. So you need to be working towards a resolution in this matter. So when he's shutting down Karen's attorneys, it's because in his estimation, maybe he thinks, all right, you know what? I just want these folks to quit popping off publicly because I want to just get all the bullshit set aside so that we could just plow through this thing.
I mean, I'm going to be a little bit more pessimistic about it. I feel like because of the way he wrote that order, again, his theatrics, he wanted his moment and he didn't want anybody to step on it or challenge it or make it any less impactful.
Well, is his moment trying to assert his authority in his courtroom? You know what I mean? It's like, that's what I don't know this judge because we've never been in front of him. You know what I mean? It's like the judges that we're in front of, we know how they operate. Like if we have, like, for instance, something in front of like a certain Kendall judge that we know how he operates and he says and does certain things, we're like, okay, well, that's that judge. You know what I'm saying? It's like
he's not referring to anyone specific. He's just
I'm just like, whatever. Right. I didn't say anything. Like, I mean, he's a stern judge, you know, and we know that he's a stern judge and he doesn't suffer any kind of foolishness and he drops hammers on lawyers all the time and he just doesn't play that game. And again, in civil litigation, when the whole battle is really the discovery process, because once you're done with discovery, that's when things are going to smooth out because that's when you're going to get your motions for summary judgments that are going to be filed. And then it's actual litigation where there's going to be heavy duty motions for summary judgment. They're going to be filed probably by both sides. That are going to be highly litigated. Those are going to be fabulous hearings to watch. They're going to be fascinating. Like the arguments.
We're always hopping in on motions for summary.
Oh yeah, we're all about it.
Because that's when we'll start paying attention. When you get,
I mean, we're paying attention now. We're on board.
Right. I'm just saying, but the fact of the matter is, in the motions for summary judgment, you get the juiciest parts of depositions anyway. You know,
because you're saying that, like, by the law, the case is dead. You know, there's no factual dispute. This case is settled by the law. And, you know, I mean, cases get booted on summary judgment all the time. It is not an unusual event. It's not like a motion to dismiss in a criminal case where when that happens, you fall off your chair. Like when Aaron Spencer, you know, like it was like me and I think Andy Baldwin were the only two lawyers out of all the lawyers that we had on our Aaron Spencer live that were predicting that thing, because it was a perfect storm, was going to get dismissed. That it was the perfect opportunity for a judge in a criminal case to do the unthinkable, which is to dismiss a case of that magnitude. And he did, you know, and like in this with summary judgments, that's not how this thing works. Cases get booted all the time on summary judgment, and it's brutal. Like I had a case that I was working down in central Illinois, driving 3 hours to court, and a case that was like factually, I thought, really in our favor. And like I was an out of towner. I got home, you know, I got like homeschooled there, and they just took me to the mat, and and I went to Allie. I'm like, should we appeal it? She's like, no, man, we got to cut our losses on this shit. We've already dropped X amount of dollars on the case. It's like we're chasing ghosts at this point. And, you know, so I mean, like these kind of cases are fascinating. And the part that we don't know, like on anybody's behalf in terms of like what kind of fee agreements they're under, you know, like we don't know if the O'Keefe's, you know, had to pay money out of pocket to hire these lawyers to file this suit, or they took it on contingency, you know, saying, look, we'll cover the costs up front, and we'll recover out of the money when we win, you know. But in those types of cases, you knew you got civil litigators that are looking at it and say, all right, look, I'm going to give you my honest opinion. I'm not super confident that we're going to win it, you know, so we're going to need to do some kind of hybrid. You're going to have to pay us something, because I'm not willing to do it straight contingency. So, and those are things that we don't know. We're not privy to that. And that goes for every lawyer in the case. We don't know how any of them are retained, you know, because there's multiple ways to do it in civil litigation. It's just, again, very different than criminal.
All right, let's pick up.
So I find that the supplemental submission does not provide sufficient support to grant the extraordinary request before the court, which is to continue a long notice deposition, which was scheduled on a date agreed to. And the request, in effect, is made 1 business day from the scheduled deposition. The timing of the request remains a concern. In addition, I am not convinced that the signatory of the letter submitted is qualified to give the opinions contained therein. Even if there had been a curriculum vitae submitted,
sorry, I totally muted that line accidentally. I just saw your email.
Wow,
Oh,
Brandon.
okay. There was one I was like, fuck, was that it?
Oh, hot mic. Hot
Wow,
mic.
Brandon.
Brando, you should probably shut your pie hole. Got a hot mic, bro.
Even if there,
See, now that judge took that in stride, because I've seen judges be like, that's fucking it. This is, get this guy, like, find this
We're
guy.
not doing
hold
Zoom
him in
anymore. Everybody get
contempt
your ass
from
into my
here.
courtroom. Yeah.
Right.
had been a curriculum vitae submitted,
Oh, so I did want to pause there, though, to say that was very telling right there, okay? Where the judge says, in addition, I am not convinced that the signatory of the letter submitted is qualified to give the opinions contained therein.
So is that like a PA, you think? Like a physician's assistant?
Well, we had
nurse.
he said who
not a
the
doctor?
so I'm looking at the motion, and they said that Exhibit A was from the lawyer,
Mm-hmm.
and Exhibit B, where are we? Exhibit A and B, wait.
Come on, I'm dying to know.
Right.
I mean, if it's a lawyer, then clearly the lawyer is not qualified to be giving any kind of medical opinion. You know, I
Right.
see Proctor.
Maybe.
He looks like super nervous to me. I don't know. Like, I don't know if he should sit. I'm worried he's going to have some kind of mental breakdown. Yeah. I'm his lawyer. I know. No, that ain't it. It's got to be some kind of somebody in the medical field. I am
It doesn't say
Proctor,
in here. It doesn't.
botanist. I take his blood and it looks like oil. I'm concerned. All right, move on. Like,
I
if
don't
you
know, but I'm just
I get
surprised.
it.
'Cause I
Like,
read it. I
play it.
remembered one was Mr. Oh, it's the very first line.
Oh.
So it's A was the lawyer and B just says medical documentation. So,
the keeper of records.
so I think that it's the person not qualified because he says the affidavits. So the signatory of the letter submitted. Okay, so that's the medical documentation. So I mean, that makes it seem like it's not like the guy's got a broken leg, right? The guy's got like a medical thing that someone can just say. He's like, I don't even think whoever wrote this is able to like make the kind of, opinion that they just made. So we'll play that one more time.
In addition, I am not convinced that the signatory of the letter submitted is qualified to give the opinions contained therein. Even if there had been a curriculum vitae submitted,
Sorry, I totally muted that
convinced-
line accidentally. I just saw your email. Oh, okay. There was one I clicked and I was
Interrupted
like,
the judge, like we don't even know what he was going to say.
Wait, you skipped where the guy said fuck.
Even
Like,
if
that
there
would be
had been a
fair.
curriculum vitae submitted, I am not convinced that
It's
it would
not
show
professional.
qualifications to give such opinions. The opinions are general in nature, do not provide any detail relative to the information referenced in the first paragraph of the letter. The opinions turn the request to, in effect, a request to continue a deposition indefinitely, which is contrary to what Mr. Proctor's counsel stated this morning.
All right, so let's pause right there. Somebody's making opinions that they don't even really qualify to make. There's not even a curriculum vitae. So again, this is not like the guy's got a sick stomach. And now the judge says, based on this, it's like they're asking for this to be continued indefinitely, which to me seems like they're saying this man cannot deal with the stress related to this issue.
Right.
Period. And if
He's
it
literally shitting in his pants.
right,
He's
this
wearing
man-
Ben's undergarments because he keeps involuntarily shitting his pants. That's what's happening. He can't I cannot subject every other lawyer and the stenographer in that room to the smell that is emanating from Mr. Proctor because he cannot control his bowel movements at this point in time. Shit has really hit the fan. It's got to be something like that.
Right. And I mean, I guess it could be he can't take the stress on his heart by being asked about this. So in theory, there could be some sort of tie to a medical condition like that. But I mean, it's clear, whatever it is, it's like he either can't emotionally or physically deal with the stress of being questioned about this information. I mean, it's in the words, right? Because why is he saying this reads like he can never do this ever? So either he's having a mental breakdown or he's got a heart that is just gonna explode if he's asked about why he's a racist.
And here's the deal. I'm
misogynistic
gonna
pig.
rest on my last rant. I don't care.
Or
Get
he's
your ass in the
constantly
seat.
shitting his pants. If you
No, not that one. The rant
Oh.
for it. That was just my medical opinion.
Oh.
Which, I am a Juris Doctorate. I'm no medical doctor, but I am a doctor of law.
Yes, he is a doctor. He is a doctor.
True.
All right. So, I mean, these are the words the judge is speaking, and it gives you clues.
Of further concern is that the opinions appear to be by committee, without all committee members signing on to the opinion. Finally,
So this man is being treated by an entire committee. It takes a whole committee to handle this shit that's going on with him.
It's a nightmare scenario with Proctor. Like,
I mean, he's lost his
no
shit.
no one is like, but it goes beyond Michael Proctor. Like the waves that are coming off of Proctor, the wake that he's left behind him is
Good made his own wake.
to the MSP, to everybody that's in contact with him, anybody in his orbit. It's like the guy just created a whole bunch of problems for a whole bunch of people. And, you know, he's flaking out. It's to be expected. I'd be flaking out too. Like, I'm not going to restate my rant.
I'm just going to say, you know, good made his own wake. May he drown in it.
I can't. I haven't even read the new report. We're going to
Me neither. I just know it's something.
Yeah.
So, and if it's that bad, it says he made his own damn wake.
Yeah.
So, all right, let's see what else the judge has to say.
The dates in the letter show that the issue before the court could have been handled much earlier. The motion for a protective order is denied. The witness shall appear tomorrow for deposition at the place and time set forth in the subpoena.
Oh,
Your Honor.
Okay. Thank you very much, Attorney Stellingson. I'm calling.
I don't know who that one was. Got another person chiming in. And then the judge gets muted.
Your Honor, you were muted there. We didn't hear what you said.
Your Honor, I am not a cat.
Oh, Your Honor, I'm not a cat.
Your Honor.
Your Honor.
We didn't hear, you got muted. We didn't hear what you just said.
Okay. Did you hear anything?
No, you said Attorney Seligson, and
It was
that was
brilliant.
it.
It was genius.
Your Honor.
It was brilliant, I'll tell you that. But Attorney
doubt.
Seligson, I was apologizing to you if you felt that I cut you off, but the issues you were raising are not the reason why we're here at 4:30 in the afternoon. All right.
I understand, Judge. There is one issue, just
but I want to
very
bring it up
brief,
again.
is the deposition. We appreciate the fact that the deposition is ordered to go forward. An order to go forward tomorrow is problematic. We'd like to get with counsel for Mr. Proctor and get a prompt new date that works for us. This tomorrow doesn't work for our scheduling, unfortunately.
But hang on. I'm going to have the clerk talk.
Right, so he has to talk.
Given what I've heard about the length of the maybe 3 depositions that took place in this case, isn't going to be done in a day. So why would you have something else scheduled tomorrow? Why wouldn't you just continue until the deposition is completed?
Well, we weren't certain that we would not conclude it tomorrow, Your Honor, but people's schedules just don't allow for it to continue.
So the judge is like, wait, he was supposed to be here today. All these depositions are going really long. Why in the hell didn't you clear tomorrow just in case? So that now he can have to show up tomorrow to continue what, you know, but whatever. So that's, I think we can end that there. And I just want to bring back up, let's see, wait. This one real quick. Sorry. This is what the lawyer was saying that he was focused on here. Okay, because the judge says, I followed up with Attorney Segelson with his reference to strategically preparing for the deposition because I read in the media of an appearance on the Today Show Friday morning where Reed said filing her new civil lawsuit was always part of a plan she had. I don't understand why he's acting like that's surprising, you know? And then beside her were her lawyers who cast it as institutional corruption, because there's no chance in hell this wasn't always part of what she was going to do. She was trying to do it all in one suit before it got moved to the feds, and they had to wait till the city or the I don't know if it's technically the state, you know, made their you know, they had to do their shit, whatever that stuff was called, like make an election or give some kind of notice. They had to wait the clock out on them to do that. So, you know, her lawyer wanted to address like that and clear that whole thing up, but she also wanted to address, what the fuck is this notice thing you're talking about? Why do you think it's unreasonable for me to not tell another lawyer about a non-party about a lawsuit being filed? It was absurd, but as we saw, the judge, you know, the judge cut him off. So after that, basically we have the order that he just read. So I don't think I actually need to bring that one up. So then you had the order on, let's see if I can. Okay.
The dog cannot make up his mind.
I know. He wants to be with his daddy. So this was the order on the impoundment. Okay. We heard that they agreed to impound it. And he said that based on the particular facts of this case, taking into account all relevant factors, including the nature of the parties in the controversy, the type of information and privacy interest involved, the extent of community interest, and the reason for the request, I found good cause to impound, and so order the impoundment of, for a period of 30 years, the affidavits attached to the motion. Which is interesting because they asked in their motion for him to impound it until further order of court and keep that order in effect until the end of the matter. And I think they were probably going to ask, did Bob just leave me here?
I'm back. So, you know, I did that 3-finger thing on the pad where pulls me right out of the
And
hole.
I don't know, maybe I didn't pull this thing up again that I keep doing because it started doing that other thing. So the wait, I think I did do that. So the nature and the parties and the controversy, that whole thing was what I was reading. For 30 years. So I think they were going to ask that it like be stricken like at the end. So it's kind of interesting that he chose 30 years because he's like, someday when this guy's too old to be worried about it and people are still wondering what the hell happened in this Karen Reed case, it's going to come out. It's going to come out. So, and also he did quote right from the Proctor's lawyer's motion. I recognize the fear of unjustified adverse publicity is not sufficient to constitute good cause. And he cites to that case. However, a legitimate expectation of privacy ordinarily is sufficient to establish good cause. And he found that there was good cause. Now, after that, I keep forgetting that I've got to come in here and so next we have his order on 6/9, wherein the judge, I'll just, I guess, share this too. So this was the judge's order afterwards. So this came down on the 9th from the June 8th, but it was filed on the 9th. I find the supplemental submission does not provide sufficient support to grant extraordinary request before the court, which is to continue a long notice deposition. Oh, basically, this is what he read out loud. So it's the other thing, like he writes it and then reads it and takes all that time. But, you know, so as Bob's saying, he threw it right back at Proctor and was like, no, you didn't meet your burden. You haven't proven shit, you know, and he had to appear for his deposition. So now we get to the order. Oh, this keeps happening. So I brought this up, but then realized it's literally the same thing that he read out. Whoops. That he read out loud. So that's what I was saying. He called Proctor out too. So can you see this now? Did it change on your screen, babe?
Huh?
Can you see the new order on your screen?
I can indeed. Well, what are you talking about? You make sure that it like you see the thing.
All
and
right,
it
babe.
says-
I gotcha.
Yeah, I can see
Okay.
it. Yes.
All right. So this is the new order. Order relative to the order of impoundment. Okay.
This is where it gets juicy.
Right. I have been advised of information that allows for a reasonable inference of a violation of an order of impoundment issued by me. Now, his impoundment order, right? His impoundment order says, well, that's not the impoundment order. That's not either. We just had it up. Oh, that's why. But his impoundment order didn't say nothing can ever be spoken about on this. He's just saying that he's impounding the affidavits and that they be released in 30 years. He did not say no one can ever speak any word of any of this ever again, you know? So he says it's ordered that each plaintiff and defendant and each counsel with a notice of appearance in this matter, and there are numerous, numerous. I think it was like 19 when I started counting, excuse me. So in this matter, as of June 8th, so the day of that hearing, so shall file with the clerk before 4:30 today, that's June 30th, a certificate under pains of penalty of perjury. So here's what it says though. As to all facts known to them, as to any dissemination to anyone, any of the contents of the material impounded. So any of the contents that was disseminated to anyone. So even saying something like, Proctor shit his pants, so he can't have his information.
Yeah, he's wearing men's Depends. He's got the undergarments.
Whatever the case may be, and I use that because no one can say they think that's serious and that we're defaming Proctor. And their in-person hearing is scheduled for Wednesday. Now I checked the docket. It sounds like these were being filed with the clerk, but not on the public record, because I thought they'd have to, file it, who they disseminated to. All counsel with a notice of appearance shall attend. And to top it off, any further attempt to take discovery from the party. Now, are we supposed to act like we don't know who it is? Proctor, whose information was subject to the order of impoundment, which again was only Proctor, is precluded pending further orders of the court. So these sons of bitches couldn't get this guy's deposition in between June 4th and June 30th. I don't know. I thought they had a date. I actually didn't continue to play until that we heard what date it was. But he shut it down. No more discovery from him. All further attempts to take discovery is precluded pending further order of the court. So, the only thing that you can assume by this.
Back up. Like we got some shit we got to talk about, because I'm here to tell you that when you, as an attorney with a license to practice law in whatever state or states you're licensed to practice law in, see a judge put in. Can you throw it back up?
I don't know what's going on.
I don't know what you're doing.
No, it's not automatically.
It's you.
Okay.
So when you see a judge put language under the pains and penalties of perjury, that tells you,
he's not
as a lawyer, that your license to practice law may well in fact be hanging in the balance if you have any intention on coming into his courtroom and not disclosing everything you know. I mean, it's similar to what the judge in Koberger did when there was the leak on Dateline, and he wrote this order up, and that was in a criminal case, saying all y'all motherfuckers need to come in here, prosecutors, defense attorneys, and tell me who the leak is. And if you don't, it's at your own peril. That's what's going on here. Like when you see those words, because believe me, the judge is dead serious about this, because again, I don't view this as, ooh, he's going after Karen. He doesn't know. He may be assuming something, but he doesn't know.
Right. And I got to take it back.
All the lawyers.
Because he did have a deposition. He was deposed. I don't know if it was finished.
Well,
At least
it sounds like it wasn't finished.
And I wonder if that's part of what because what it says is, I have been advised of information that allows a reasonable inference of a violation of an order of impoundment by me. He's been
Kim,
advised of information.
This is exactly what I'm trying to say to you. Kim asked, do you think the lawyers will admit it? You are putting your license to practice law permanently in jeopardy if you're going to step in front of a judge who has told you under the pains and penalties of perjury. It's as serious as you get.
And he's been advised of something.
He knows something.
He knows something.
So every lawyer that may have said anything to anyone is now going to have to fess it up.
Right.
It's
if
that
they
simple.
told their secretary, for example,
Yep.
their assistant, their paralegal, Proctor shit his pants, and now he can't do a deposition and we have to reschedule, he's going to have to say, well, the only person I told was my assistant.
I told my wife when I got home that we were in the deposition and Proctor shit his pants. And, I mean, it was unbelievable. Like, I tell my wife everything. Like, I never thought that she would text her friend, who then would turn around and text it to her friend, and a whole telephone game would have. This thing tomorrow, somebody is getting outed. And if any of the attorneys had any hand in sharing the information, they are not going to put their license on the line. They're carefully considering what their options are tonight in preparation of stepping into that courtroom tomorrow.
They filed something as of at 4:30 today, though.
Do we get it? Do we got it?
No, it's not on. It's not. I
Oh,
checked the
yeah.
docket.
It's impounded because all the shit's impounded. Right. And we're not going to get to watch tomorrow. I'm sure.
Wait, is that for real?
It's impounded. Like, they're going to be talking about impounded shit. I hope that we can.
No, I think he's got to have that public. He doesn't have to say what they said. He just needs to say.
I hope so.
I mean, maybe not.
I hope so.
I really was looking forward to it.
Yeah. Yeah.
Maybe it's not going to be open.
Maybe it's not. I don't know.
Well, somebody who's those? Aren't there people that've been getting their cameras in the courtroom and doing it on themselves when the judge is putting it out there?
Like, I don't know. I don't think so.
I thought somebody.
I mean, Law Girls Not Attorneys have been doing that as much as they can.
Yeah.
I know Grant has been in there. Like, I'm sure he'll be there. But it's one thing to hear it secondhand, but I mean, Grant's a lawyer now. He passed the bar. And yeah, Boozy Beauty's going to be there. So, I mean, we'll have people in there. Oh, Boozy has the newest document.
What newest document?
I guess the one that was filed under.
Wait, I'm looking at the docket right here in front of our face.
Laura Knight is saying Boozy has the most recent document. If that was filed under if it was impounded, Boozy should not have that document. And
no, it must not be. So here's I'm going to share the docket. Okay.
Boozy probably walked her ass over to the courthouse and got her a copy.
And got a copy before they put it up.
Yep.
So here's what it says. All right. So here's.
Oh, I know that. He's like, I mean, we all know who Grant's mother is, right? And Wendy Murphy is as crazy as a shithouse rat. Like, you remember who Wendy Murphy is, right?
Oh yeah.
Yeah,
She
the
made a
gal
big
who
old
says that
scene.
all defense attorneys go to lie, like their first class they take in law school is liar class or so. It was some crazy shit. Like that was the first time Allie ever popped off on somebody on Twitter. She's like, "Oh no!" Like she went off, and then of course Wendy blocked her.
So you've got. So also, on or before noon, this is what we have to cover. There's so much stuff to cover.
On her YouTube.
Huh?
She said she posted it on her tubes. The tubes. Well, what it is, she don't have it, Tammy's saying. Aurora's saying she does have it. We've got a debate.
All right, so here's what I'm showing you right now. Everything that's been filed. So it was supposed to be filed today, right? And the judge just came out with this yesterday. So you have Karen Reed's opposition to motion to quash filed by Tully. All right. So this one's, to get these guys, compel Nicole, Brian, Jennifer, Matthew, Allie, and Higgins to attend their depositions and to produce their stuff. Then you've got Nicole, Brian, Jennifer, Matthew, Allie, and Brian Higgins memorandum in opposition of their motion to compel. And she replies to that. Now you have a compliance with Rule 9C, which has nothing to do with this.
She just doesn't get it.
The word
She
certificate.
doesn't understand there's not shit on. When you're looking at the screen, are you not seeing that there's not a document? That's where I'm getting lost.
You can see this right here.
You are the queen of not using two screens. That's why you're fucked on this
I'm
one.
looking at it. I see it right here.
I just put it up, Chief.
Oh
yeah.
It's doing something weird. It used to always let you just, once you shared it, it was shared. So I'm sorry. Jesus.
That's what I'm telling you. You have two giant, enormous Thunderbolt displays in front
I'm
of
not
you that you
using
can.
those. Then I'd have to
You
look
should
like
be,
this.
is my point, my love.
I'd be looking over here.
Oh my God. So what? You have a great profile.
All right. So sorry. So then you have this certificate of compliance. Don't get confused by the word certificate. Their Rule 9C certificate is not this certificate. Okay. It's just, I certify that I have conferred with counsel for Nicole and Brian regarding the subject matter of this motion before filing it pursuant to Rule 9C. A conference took place on June 18th. That has nothing to do with this thing. Okay.
So Boozy posted the list of attorneys who are excused and who has to appear via Zoom. So that's
I got that. That's right here. Attorney. Whoops. Attorney. Oh, damn it.
Oh my God. What's happening?
In the hell?
Oh man, you see, this is what happens when I leave Allie to steer the ship. It's like you guys like to talk all the shit about my tech wizardry, but this one, she might be worse.
All
than me.
right. Okay. Oh.
Oh my God, I'm getting dizzy. I'm gonna have a seizure. Okay.
All right.
What is happening?
The judge did excuse certain lawyers. So right here, he says
we got a minute order.
By order on regarding the July 4th hearing, attorneys Beaton, Shipley, and Waters are excused. Attorneys Fell, Horowitz, Little, and Mason may appear virtually. So what's that mean? I mean that Jackson's got to get
hi.
All right, can you see this?
I can. Like every time I try to blow my screen up, I keep exiting the entire StreamYard. All right.
So
yes, I can see
these lawyers are excused, and the others can appear virtually.
So Fell, Horowitz, Little, and Mason may appear via Zoom, and Beaton, Shipley, and Waters are excused.
Right, which sounds like Jackson has to get his ass from California because it sounds like maybe he didn't ask to appear virtually, but isn't Little in Jackson's office?
Yes.
Or is that a different Little?
No.
So
Little.
I don't know. So again, then you've got, this is these guys asking to compel responses to plaintiff's supplemental keeper of records subpoena for Aiden Carney. It has nothing to do with any of this. And then you have an affidavit in compliance, which again, since the last one didn't actually show, I will show you. It has nothing to do with this. It has to do with on April 21st, a keeper of records. This is just a certificate, a certificate they have to file to say
They
when they
served the
need
subpoena on Aiden.
right and where it is, and that now they've complied with everything and they're ready for this matter to get heard.
So when did they serve it? What did he have? 30 days to comply. So
You're getting
when
sidetracked by that. As of this date, no opposition or response of any kind has been received.
well, no, yeah. But when was it served?
June 30th, June 3rd.
Oh,
Oh,
really?
motion to compel.
On April
The keeper
21st.
of records subpoena on April 21st.
So he was served with the he acknowledged receipt of the subpoena on April 21st of 2026.
Right. But my point of showing this is that when you see certificate, affidavit
Mhm.
and, certificate rule on different rules, they have nothing to do with
Nada.
right, with what was supposed to be happening here. Like this certificate is
Right,
just
that's all just like the
Right.
rest of the case is still going. Shit's getting filed left and right. There's other moving parts that everything's still moving forward. We're talking about one limited circumstance, and it's Proctor's deposition, and then the shit that leaked out allegedly that the judge became privy to from somebody. Somebody ratted on somebody with the judge. Somebody went and had some kind of conversation with the judge. It sounds like it was ex parte to me. Like, I mean, how is like who's communicating with the judge unless like the judge's clerk is like, hey, judge, guess what I saw on the Twitters? I saw somebody posted something about Proctor's Lukey Belinat, some shit. Like,
Right.
who knows?
And
how
I
the
was
judge-
wondering, I was going to say, should we go through social media? Because one thing I do remember is Aiden posted that he had her on X that someone reported to him that Proctor was like having a breakdown of some sort, like hugging his lawyer out in public with his lawyer consoling him after the deposition. I mean, that's not a leak. So it can't be that. That's like someone who was there, observed with their eyes.
And I don't think it was an attorney for the plaintiffs because, like I'm saying, that's an ex parte meeting with the judge or communications with the judge, which is not allowed. We're not allowed to have ex parte. We can motion it up and say, hey, judge, we need to speak to you ex parte. You can't just go ahead without the other side being there or without CCing them in terms of saying, all right, look, don't you guys like Allie thinks that she looks better when she's on that side, when she looks the exact same.
No, I don't change. I'm
see it.
used to you being
Let me
first.
see it. Let me see it.
We seem the exact same.
Oh my
I'm the
God,
exact same picture.
You
I
look
don't-
totally different to me. I don't know what you're talking about. It's insane.
It's not that. It's just I'm used to seeing you on that side.
Okay.
You're first. I'm second.
Oh, okay. I'm good with it. I don't care where I'm at. I'm easy.
So let's see if we've got any like super compelling questions or information that.
True dat.
Yeah, right. So JPJH says, let's not forget Reed made a motion to combine all of these cases before. Speaking of being blessed with tech wizardry, I was in the middle.
Sorry, babe. I'm picking on you.
Yeah.
You're so sweet. I love you.
I-
Allie worked very, very hard today putting all this shit together. So I don't want to hear your shit out there. They look so disorganized. Their YouTube presentation was very disorganized. Like, who decided to start calling it YouTube presentations? I think it's stupid. I hate it. I'm never.
All right, let's not get off on a tangent.
Like all of a sudden that terminology popped up. Like if it's a live, it's just called a live. Why is it a YouTube presentation? It like something popped
Well,
up.
because it has to be like if you're talking to a judge who doesn't know shit, saying a YouTube live is like saying, it's my Fagerbacher.
Maybe you're right. Maybe that's where it came from. Maybe it was when YouTube started becoming a thing of relevance in certain court cases, and they're talking about YouTube. Maybe it was all the way back to like that hilarious hearing with, one of the two, where I clipped this judge. You remember this? Like this clip I love so much. It's
I
worth.
actually think that Bob may have referred to it as a YouTube presentation as well, because you have to tell the judge what it is. When you just say, well, there was a YouTube live stream or
it's on the YouTubes, Judge.
Like,
the YouTubes. I don't know what that is.
Right. It's a
Here,
presentation
this judge.
on
Maybe it
YouTube.
was this judge.
Down. Oh, I said overruled. Sit down. Sit down. Oh, I said overruled. Sit down. Sit down. Oh, I said overruled. Sit down. Sit down.
I love it. That judge was great. He was so good.
That one of Aiden's things?
That was Aiden or Kelsey. I can't remember which one. The chat will know. Which judge was that? That guy was awesome. He was just like an old curmudgeon up there.
Somebody says the one time Bob isn't reading the chat, so I don't know what they were saying.
Oh, yeah. Wait, are you guys talking shit in the chat? What you doing? Oh, yeah. Thanks, Brooklyn. You're the sweetest. I love Brooklyn.
Yes, check out Buried. So anyway, I was starting to read. JPJH said, let's not forget Karen Reed.
Exactly.
Can you guys believe this? You've done that 3 times now.
What?
I keep putting this up and starting to read it, and then you click on somebody else's shit.
Oh, sorry. I'm peeping the chat. I'm peeping the chat.
Okay, well, just don't click the chat. Just peep it.
Yes, ma'am.
That Karen Reed made a motion to combine all these cases before she filed them for judicial economy, which makes sense. And this judge, Judge G, denied that motion. He does seem to blame the Reed team more than the. Oh my goodness.
Oh, sorry. But Andrea here is saying, but nothing even got. If only the people in that room knew that the DEP was postponed after it had been going for a while because something happened with Proctor, that is a leak. And if it's related to whatever was contained within the affidavits, it's a leak.
No, but the closest thing I keep telling you is Aiden saying that someone observed.
Aiden needs to shut the fuck up. I wish he'd
someone
quit
observed Proctor being
He's
consoled.
making his lawyer's job
Can I
so
speak
much
words?
harder. Yes.
Someone
I say that with great affection. He needs to shut up. Like, quit talking all the time about shit that is being litigated. At least talk all you want, but just pick your words more carefully. Ugh, reckless.
All right. So anyway, that somebody who saw with their eyeballs Proctor being consoled after his deposition by his lawyer sound like, that's not a leak. That's something somebody observed with their eyes. And we all know from the papers that there's some highly sensitive medical shit that's being talked about. There are all these things that people can read through the words that were used to determine that he cannot handle, either emotionally or physically. He cannot handle being confronted with this shit. So what's this mean?
Wait, that was not Cosgrove. That's a judge. I promise you that clip.
No. They're telling you that Cosgrove was the one who called it a YouTube presentation.
Oh, no, definitely never.
Oh gosh,
presentation. That is like, now I'm adopting Cosgrovisms. Not happening. Sorry. Thank you. Now I can officially bury it. It's dead and buried in my mind.
It was always dead and buried. All right. So Holly Ann Crow, member for 16 months. Says hello, DD. Let's do this.
Let's go.
Welcome. Thanks for your continued support. And then Dawn says, how long have I been here? 29 months.
Love you, Dawn Burke.
Yes. OG. Thanks for your continued support.
Wait, we had a 36-monther last night. Wasn't that? Like in the last couple nights?
No.
30 something. Yes. Don't make me go through.
No, I feel like it was a 28 or 29.
No, man. No.
But I thought we had a 30 something.
It was like a 36er. It was like a 36er.
I don't know if
it was huge. Huge.
Okay.
Huge.
All right. A Miss OG Member for 13 months says, thank you for your content. Thank you for your continued support. Venus Blue Cupcake. We love our cupcakes, or we love Mel's cupcakes.
We do.
I'm helping with a Facebook Live. Want to support Replay Crew. Thank you both so much for the Ellis interview. It was such a great catch up. Love you big. Love you all big. So
Such
wait,
a
is
good
she
live.
saying I'm helping with the Facebook Live, but want to support us by making this comment? Oh, thank you, Venus Blue Cupcake.
We love you. Thank you very much, Venus. We appreciate the support. We truly do.
Aura.
Say that 5 times fast, huh?
For 15 months, says family hugs, drawn and one-quartered in
Drawn and quartered in Town Square.
Oh, that's what he should be?
Drawn and quartered in Town Square. Tarred and feathered and ran off on a rail.
Right.
Right.
Thank you for your continued
All the
support.
old-timey Boston shit.
Yeah.
Yeah.
And I put this up before, but MBW gifted 5 memberships. Thank you very much.
Thank you.
And it's worth rereading because Tiffany said, sorry to interrupt, but just joined this live tonight. Please watch the amazing interview with Sean Ellis. That is Sean Ellis of Trial 4, who was represented by Rosemary Scapiccio. And Defense Diaries. I've never seen such an impactful interview since ever. Good job, Bob and Allie and Sean and Rosemary.
I don't know. I don't know how you don't ever get them. I cried. I had to go get a tissue because my nose was starting to run. It was fun. I'm like, all right,
was emotional.
Do I wipe my nose on a live or do I go get a tissue because I'm crying? It just was the realest shit you're ever
really
going to
was.
hear. It was the most authentic, realest shit you're ever going to hear from a
And
guy
not
who
because
did
of Bob and
22
I.
years
Right.
in prison for some shit he didn't do. And it's like,
thanks to the
here's the
Massachusetts
deal.
corruption machine.
Anyone who watches that and isn't moved, I will give you a full refund. You will email your rebate to me personally, and I will personally send you a rebate of $0 Fix your life. Watch it. It truly is an incredibly powerful live.
I mean, Sean is an incredibly
He's an amazing human
person.
being. His emotional capacity is unbelievable.
Yeah.
It's unbelievable.
I was very impressed. And thanks for your generosity, Tiffany.
Yes.
And harbinger of imminent death.
Oof. Daunting.
If the judge orders that Colin must appear for depo on some date or be in contempt, is the Army likely to comply, or would he have to issue a warrant? No, I don't think that I don't know is my answer, but I don't think the Army is likely to unless they're
I started
forced
seeing
to.
information online, namely Twitter, and I think in chat a little bit as well, wherein people were saying, look, he's not even in basic training yet. He's in some shit.
Yeah, something about he didn't do well in his I don't know if it's an officer or an admissions test or some shit. And they're like, all right, you got to go get some more schooling. You got to get you got to do better, and then you can reapply. That's something that I heard. I don't know if it's true. You guys are way more on top of all of that than Bob and I are, just because everyone's talking about it and we just can't follow it like that. But actually, I wanted to go back to I think it was not a super, but one of the comments that you put up, if there's a leak, how come none of us have heard it? I'm all over these,
Yeah, we have no idea, Jody. My entire point is when you say as a judge, under the pains and penalties, that the lawyer's sphincters tighten. And if one of them did, they then have to evaluate the risk of walking into that courtroom and potentially not being truthful with a judge.
I mean,
no lawyer is going to take that lightly. I'm telling you, trust me. Like, I have no idea. You could be absolutely right. Maybe it wasn't. I would hope it isn't a lawyer, because if it is a lawyer, that's a real problem.
But I want to put this back up again, okay?
What?
Because the judge is saying, let me get back to.
Oh yeah.
Wait.
What order is that?
That was his order about the lawyers. Here. This time I'll do it. Make sure I actually click it.
Yeah, you see, like the problem with Aiden is Aiden's in a trick bag. Like, Aiden is in a position where he has to go live because he really does need to raise money for his lawyers, because lawyers in a case like that are not going to be cheap. It is a highly litigated case, and it is going to trial, short of the motion to dismiss getting granted, which, again, it's very rare. Like, if you're of the mindset that that's going to get granted, and y'all know I love Betterow. We love him here. He comes over here all the time. He's a fabulous legal writer. He's got an incredibly keen legal mind. His arguments are strong. However, all that being said, judges in criminal cases, it is the most extreme remedy to dismiss a case or all the charges so that the entire case goes away. So, like,
why did we get sidetracked with that?
Because people are responding. I'm responding to people in chat to my comment that Aiden needs to really focus what he's talking about and leave a lot of shit to the side, because he's not in a position financially where he can't go live. He's got to go live. Like, that's how he's generating his income. That's his livelihood. He's not in a position not to be able to do that.
Well, not with all these attorneys.
He needs to be more careful with what
we have no idea that has anything to do with anything.
I hear him. I watch his show.
But I'm just saying, I started this by bringing up that he made that X post, and that wouldn't be a leak. That would be something that someone saw with their eyes.
Generally, I'm not talking about this in particular.
Okay.
I'm talking about all the shit that he says about all the cases that are being litigated, namely his shit. And I'm hoping that he'll watch this. It's because I don't want to have to text it to him.
All right. Can we move on?
What do you give a shit? I'm trying to give
do that off of our live. Like, I don't know what we're talking about right now. Okay. So in any event, the judge is saying here that the certificate under pains and penalties of perjury, all facts known to them as to any dissemination to anyone other than the parties and counsel of any of the contents of the material impounded. So again, that's like if he were to say to someone to say to their paralegal, their assistant, their secretary, whoever, we got to reschedule this deposition because the man shit his pants.
Oof.
And that's not what his impoundment order is, not that none of the information, none of the contents of the material, nothing about what's in there can be disseminated by any means whatsoever. So I think he's pushing here for a little more than what his impoundment order says. So I don't know when he says he's been advised of information that allows a reasonable inference of a violation. Well, that would be if they actually shared the document, which was what was impounded.
Or something contained within the document.
But the judge didn't say that in there. So
read it again, because it's so small I can't see it.
Well, he said, I've been advised of information that allows a reasonable inference of a violation of an impoundment order.
It sounds exactly like what I just said. I don't know what you're talking about. That sounds like something specifically in an impounded affidavit that was spoken.
Right, the contents of exactly. But what I'm saying is his impoundment order, okay, doesn't say no information can be discussed or disseminated.
Oh my God. Really? What do you think impounded shit means?
That the documents themselves were impounded. That the documents themselves were
impounded. That means you know talkie. Release the information. If the public could get it, it wouldn't be impounded. You know that. Like, are you what? Come on, girl.
I'm just saying, who knows what was said?
Well, the judge disagrees with you, madam. That's what's happening right there. All right, so we got a few Venmos as well that I want to give some love to.
20th Century Foxy says Grant's not a lawyer. Defamation.
What? Is that true? I thought he said he passed the bar. Has he not gotten sworn in yet? I thought there was like read a post from him. I've seen it with my own eyes that he passed the bar. And when you pass the bar, then you get sworn in. What was like? How long did we do? Like it took us a month. Like a month.
I think longer than that. We were in Italy for
a
month.
No, we weren't. We were back from Europe.
Right, but that's what I'm saying. That's how much time passed before we were sworn in.
Really? It was a long time ago. I'm
I
not
don't
going to
know.
argue.
Who
I'm not going to
remembers?
argue it.
I don't remember.
Well, you're sure acting like you do.
I'm just saying it could be
I mean,
some
you
time.
can't even remember where we went in Europe when we went there. Like this debate someday. So Allie and I had like old-timey, we had an old-timey like handheld camcorder that had like the tapes, you know, that you record on. And we lost the charger. So we have all these magnificent videos that might as well be like Super 8 movies, like the old projector shit that we haven't been able to watch. And Allison and I have been having this debate because we flew into Amsterdam. This is like right after law school. We're like, oh, we have some of our law school money, and Allison sold stock. We're like, let's go to Europe for 3 weeks and just like completely fuck off. Like no plans. We'll just travel where everyone. It was amazing. And so we've had this debate as to whether we went from Amsterdam to Italy, which is what we did. But Allison thinks we went to Amsterdam to France. So like a debate that can be solved.
Back to Amsterdam.
That's that we ended in Amsterdam.
All right, I'm glad there's a record of this. So Allie says Amsterdam, France, Italy, Amsterdam. Bob says Amsterdam, Italy, France, Amsterdam.
Well, it's always Amsterdam. That's where our flight flew into and left from.
Okay.
And if you'll remember, we missed the train, or we missed the flight on the way back because our train went a little long. We flew from Amsterdam into Italy. I'll never forget it.
Don't,
because they were walking around in.
Okay, we don't need to get into all that.
They were like walking around with machine guns in there,
oh,
like near the luggage. I'm like, holy shit, this is intense. You know, because it's like, you know, the States, you're like Allie thought I was going to like spill some like state secrets. I'm not a moron, woman.
I mean, it sounded like you were about to.
I know, like, God, like sometimes you just think I'm so stupid.
All right. I'm just going to go with what Brooklyn said, which is wow, Bob.
Wow. Wow.
Like
all right. So our daily Venmo angel, Kim, sent us 25 and said, thank you both. And because I didn't give proper love to our Venmo friends yesterday, Kim also sent 25 yesterday as well. So thank you 2 times, Kim, for that. We really, really appreciate it. And then Ain't So Plain Jane sent us 25. She said, Bob was me last night watching Sean Ellis. Tearing up emoji. Allie is hosting Queen. Agreed. And thanks for all the knowledge that you constantly, oh, dang it, that you constantly share with us. Late night matas are also hilarious. Yeah, you guys are lucky. Allison fed me.
You can't tell, kind of, but yeah.
I'm in a great mood.
I know, but it's a little too great, maybe. I don't know.
I'm a little much. Am I? I could see that I like by somebody who's just coming in for the first time. You're like, that guy, he's a little much. I could say it would be a fair evaluation of my performance this evening. And then Tom sent $10 saying, hope this Venmo thing works. It did. Thank you very much.
Thank you.
Tired of giving Google my money. Proctor isn't a racist. He's a complete psychopath. Just a Birdman opinion. Love it. Love it. Love it. All right. So, and then I got to give, we had a few from last night that I just didn't get to give the love.
Well, while you're looking for it, Dr. TJB became a member. What does Doc get?
Oh, family hug. That's what Doc did.
Thank you. All right. What you got?
So, Nurse Hannah sent $10 last night. Thanks for giving people, like Sean, a platform to share their story. Hopefully We will all learn from these horrific experiences. Thank you. Thoughtful Venmo. Thank you for that message. Like for me, that's where my heart is on cases like that. So, and same with Allie, it's like that.
Sure.
That's like
Roosevelt Media News says, having watched all of the Reed civil hearings so far, it seems plain to me the judge favors we call them should have been house suspects, slash MALOE, which I think is like all the people or something, or Massachusetts low. I don't know. MA is so corrupt.
Roosevelt, tell us what LOE is. We're old. We don't understand all the acronyms.
Law enforcement officers.
Oh yeah, you did it. Nailed it.
Thanks, Roosevelt.
Thanks, Roosevelt.
All
right, Kelly. Oh, all right,
go ahead. No, you go.
Kelly sent a $7 Venmo last night. Again, amazing interview. So grateful you and Allie fight the good fight. Well, thank you so much, Kelly. We appreciate that very, very much.
Aunt BB says, I'm sorry. In my opinion, this is Bev all over again. Wondering if phone calls weren't had. This is deja vu for AJ. You may very well be right, because it does to me at least seem that this judge is, in his mind, he thinks that the Reed team is like up to no good, and he's looking. I didn't like what he did on there. Like, he had it in his mind that whatever Karen said with her lawyers next to him, this was all like, a plot to go on a national thing and say that this is about corruption, and it rubbed in the wrong way. And then he kind of interpreted things moving forward the way he wanted to.
It's interesting to me because Karen has so many lawyers on who they have elected to kind of be the talking head, the speaker.
Right now, the talking heads doesn't matter, right?
I mean,
it doesn't matter until you get to motion work.
It does and it doesn't. I mean, for appearance sake, you know what I'm saying? Like, it does. I mean, in terms of substance, you're right. It doesn't really mean jack shit. But in terms of appearance sake, it's interesting. It's not something that wasn't discussed heavily in terms of who was going to be kind of the front man or woman, so to speak, like in the early stages of litigation. You know what I'm saying? So it's interesting.
And then Aunt BB has also been a member for 3 months. So thank you for your continued support. Then he needs to call Bev to hold his hand.
Oh, Judge Cannone.
Yes.
All right. So Christy Silo last night sent $25. Says it's been a while since I've donated and even caught a live. Always watch the replays. Thank you. And of course, Allie too. Great show tonight. I always appreciate the wrongful conviction shows. Well, thank you. It's like, like I get all salty and shit during it. I'm like, where are all the people? Like, why aren't you guys watching this shit? It's like, everybody's like, oh, yeah, whatever. Watch it.
All right. So Leighton loves her. Gigi. Leighton loves her. Gigi says, I love you both. YouTube keeps unsubscribing me.
That's outrageous.
I don't know why it happened.
I'm going to write a strongly worded letter to YouTube.
And then she came back with 5 memberships. Thank you very much for your generosity.
Thank you so much.
Now I need you to say what Kim M gets.
Oh, you know what Kim M gets? Oh, family hug. That's what she gets.
Welcome, Kim. We appreciate you. And then Lena. Lynn.
Or Lina loves trials.
Yeah, Lina loves trials.
Yeah.
Sounds like a distraction from goods released doc. Yeah, well, we don't know about that. But we're gonna go
man,
tomorrow.
Look, cat's out of the bag. The cat's is out of the bags. Like, all this shit is like, it's
and then Birdman confirms for you, and he's been a member for 5 months. It doesn't seem right, but maybe it is. It was Cosgrove who coined the term YouTube presentation. And then Roosevelt Media News comes back and says, on July 6th, Turtle Boy stated on X that Proctor was in Florida receiving mental health treatment. That was 2 days before the protective order. But I think this is what the judge is talking about. Well, if it was 2 days before the protective order, then I don't know what the judge is talking about. I don't even think they had it yet. So he might have been getting that on his own. Let's just do a little fact check right here. I'm going to come back to this. So here's what happens. I click share screen. Then I click share and it takes me to the screen. So then like out, and as it always does. So I had to come back. Right. That's weird.
That is
so
weird.
If we go to, well, so on the 6th, that is when, where is it though? Oh, yeah. On the 5th, he filed that protective order that we just read, which didn't say anything more than what, I mean, we just read it. So it didn't say anything. That gave way less inclination of what it was about, you know, and then you had this order from the judge. This is how it got set for the June 8th, that he says the moving parties provide information concerning when counsel learned the witness is unavailable for deposition preparation. He wanted to know, how long have you guys known that Proctor wasn't even available for you to prep with? 2, when was Reed's counsel informed? And 3, why deposition preparation could not have taken place today or this weekend? And 4, supporting witnesses' unavailability as referenced in the last paragraph of page 3 of the motion. This may be filed marked provisionally impounded with a supporting motion if warranted. So when they filed whatever they filed, it's like, even here, the opposition to the emergency motion, that's not even, you know, that's like impounded because it's not here. And then the affidavits and supporting material on the 8th, you know, not here, impounded. So I don't think there was anything filed yet until, well, maybe not. Yeah, it said by June 8th. I mean, I guess they could have filed something, but we would see it here, and we don't file the 6th. So I don't think that there was anything that they would have known. The other side would have had the paperwork. Now, is it possible?
Yeah, he's like, you got like,
Dude,
I thought, oh, sorry.
Why do you keep doing that? I'm not kidding.
I'm reading the chat.
I'm in the middle of talking about something.
Sorry,
and then
honey.
you pull up a chat. I could give a fuck about whether Ellis is a goddamn lawyer or not. And now you made me use
sorry, babe,
and people are going to get all upset.
Oh my God.
So going back
sorry
to what
all the peoples.
Going back to what Roosevelt said on July 6th,
the body of Roosevelt.
Turtle Boy stated on X that, God, I'm serious.
I am in deep shit, y'all.
Proctor was in Florida receiving mental health treatment. It's possible that somebody spoke those words to the lawyer and it got out, but that would be before there was a protective order. Somebody told him that, but it's also possible that someone who knew Proctor told him that. There's no, and that's a really late reaction, July 6th. I don't think that's it, but stand by. We shall see. Nay, member for 23 months, almost OG. I mean, is OG, but almost 2 years. I was reading the comment. Almost 2 years listening to quality peeps. That's
Love
getting
it.
A little bit exacerbated with one tonight.
Wow. Wow. Wow.
And
Bob needs to fix the fridge. She doesn't get it. She never watches Aiden. I know what it means.
I don't have any idea what that means.
Yeah, like, take a wild guess if Aiden says, "Oh, she needs to get her fridge fixed. Her fridge needs to be fixed." I'm here to fix the cobble.
Oh, like a
log jamming.
Oh, like a porno.
Like get laid.
Code for having sex. I get it. You boys and your code for having sex. All right, so back to Nay. Thank you for your continued support for 23 months. We appreciate it.
Appreciate it.
Aunt B comes back with another. Oh my goodness. Yeah, no word salad. He is a lot tonight. He is a lot. Like, I don't know. It's like I drugged his food or something.
You know what? I was a lot at the game though. It's like I was.
You were in a mood.
Like in a good mood.
Yeah, no, you were in a good mood. People were commenting that you were like making everybody laugh and
Like, it's like I was disappointed by the loss, but I still, it's like I realize that part of our life is coming to an end. So it's a little, it's bittersweet for me because I love doing that with our kid, so whatever.
All right. So I'm going to just continue with Aunt BB's continued generosity. Did you all see Yuri is on a cruise and attempted karaoke again? No dancing, but singing God Bless America. Apparently he has taken English classes. AJ will be happy.
I did catch that on the Twitter machine. I saw the video. I didn't watch all of it, but he didn't know all the lyrics. I'll tell you that right now.
I mean,
he was that's like me when Allie and I are at a show and like I'm mouthing it, like I pretend like I know the words or some of the lyrics, and I'm like, just so like my friends, especially if it's a band that we all like listen to, and like I can't remember lyrics to songs like that. Like some people are just like, I can't do it,
All
so
right.
I'm like,
NOLA is for livers.
Yeah.
Like,
oh God, I was going to tell you to not. That's Nola loves to give me the guilt trip, which I need, because I had promised it was going to come out today.
Well, it should have then. Redacted doing redacted. Listen, Bob, how can Turtle Boy have an RO, like an order of protection?
Restraining order on KP.
Who's KP?
Kate Peters, Crusty Panties, whatever you want to call her.
Even worse. I don't
Masshole Mafia. She's got all the
I've
names.
heard that name. Okay.
Yeah, same
and all she do with every waking moment is try to ruin his life. That can't be legal. I mean, it does seem a little odd that like this chick, it sounds like from what you're saying, is out there doing what they're accusing Aiden of doing. I don't know how she's out there trying to ruin his life. Like, but it seems like that's continued harassment. But I know none of the facts. So actually I shouldn't be speaking on this at all. So it might not be. It might be. I don't know. Redacted, but thank you. Allie from Tennessee. Bob and Allie, tell Sean he should go on Ian Bick's podcast. He has over 5,000 followers and does great interviews. They all center around ex-inmates, law enforcement, first responders, etc. All right, Bob can let him know about that. Thanks, Allie.
I'll let him know.
Alex Whittier. I don't know.
I can't.
That, like
I'm sure you're just destroying.
My eyes are already old, and now they're old and tired.
Yeah, Alex,
and confirm
you're
never watched live before, or at least one of you two comes off as possibly a little sauced. And Bob
I can tell you this: I haven't had a drink in 6 years, so it ain't me. Even though it seems like it might be me, it's not me. This is just me in a good mood. I'm just, having fun.
Yeah. But that's what I was saying. It's like I drugged your dinner tonight or something. I'll leave it for you to determine which one of you love you guys.
Good times. Good times. Good times.
Music to My Soul says, why is the judge monitoring case-related media? Articles on Today's Show and receiving info that didn't come through a filing. This seems sus to me. I mean, it is a little odd,
Is it? I mean,
he's not supposed to be learning facts outside of
what what facts?
Who knows? But he could have been exposed to who knows what.
Do we live in a world in which we think or believe that judges simply don't look at the cases that they're presiding over on social media? Get the fuck out of here. That does not happen. Like this is not the 1980s. Every judge has social media. Every judge is trolling around in there looking, seeing what's up.
But it sounds like he was just.
I'm going to ask Judge Erskine next time she's on. I'm going to ask her opinion if she thinks that, judges that are presiding over things are keeping a little bit of an eye on it, seeing what's going on out there in these mean streets of social.
All right. Music to My Soul. Oh, I just read that one.
Oh, yeah.
It's so plain Jane, member for 6 months. Thank you for your continued support. Bob, go make Allie some hot cocoa stat. Yeah, I am.
Are you chilly?
It's mostly Bob is getting me exacerbated more than I'm tired, but I am also tired. Law ZC says 5:30 a.m. in the UK. What a treat to wake up to your live. Well, thank you very much.
I
Thank you
love
very
it.
much.
Thank you.
And
Thank you.
Bob, thank the people. I mean, I think we're going to be here to, if there's something live tomorrow, hopefully we know how to get to it actually.
Yeah. I'll figure it out if
and
it's going to
we'll-
be live. All right. Look, mods, thank you so very much for everything you do. Tracy, we love you. I know you worked your butt off today with Allie to get everything lined up for this
sending me
live.
stuff left and right.
Thank you a million times over. To the trial channel, again, happy birthday. I hope your day was spectacular. Thank you for allowing us to use your fantastic content. You're a savior. It makes it so much easier for us to not have to worry about that side of it. So we're eternally grateful. Everyone go over there and sub. It's an amazing channel. They do great stuff over there. She trims the fat. So all you're getting is the meat, which is a beautiful thing. So thank you very much for allowing us to do that.
The trial channel.
The trial. I think we've been dropping the link in the chat. And then to you guys, please make sure to like, share, subscribe. I don't know what the current count is, but last I saw we were about 850 away from breaking 70,000 subs. So help us get there. We appreciate it if you like the content. I'm not always this much. Sometimes you'll get, just normal demeanor Bob. And he's still pretty decent. He still gives you pretty good content. So give us a subscription. We love those. They're free. Like, tell your friends, tell your neighbors, and share. That really helps get us out to the peeps. And that's something that you guys can do without having to give up a dime. So we appreciate that. And go back and hype Sean Ellis's. First watch it, because then you'll be compelled by your own brain to say, you know what? This thing was dope, and I'm going to hype it, because that one deserves to be seen, because it's that kind of interview. It's like, I don't know who the big guy is, and I'm sure he does good interviews, but like, coming from a lawyer that deals with those types of cases and those kind of defendants, you're not going to get the same vibe. It's worth your time, a couple hours that Sean gave to us. So I highly recommend you go check it out. And to you, all of you, whether you're old or new, I thank you so very much for hanging with us, because without you, I would just be an old man
annoying his wife.
Beep.